It is possible for ICE or Immigration and Customs Enforcement to show up to your adjustment of status or I-130 interview and detain your immigrant spouse. Now, whether or not this is likely to happen depends on a bunch of different circumstances, but it is definitely possible, and that's the topic for today's video. 3 scenarios where I've heard of something like this happening. One of them is when you are attending a standalone I-130 interview. So the reason why someone would only file an I-130 for a spouse who's unlawfully present in the US or lawfully present in the US is because that spouse may not be eligible for adjustment of status right now, or they might be on some sort of non-immigrant visa, and that non-immigrant visa precludes showing immigrant intent. For example, if you're on a student visa, you must maintain a non-immigrant intent. And if you're married to a US citizen on a student visa, you can file just an I-130 without technically violating the terms of your student visa. Whether or not that's a good idea or not is a question for another day. Speak with an immigration attorney before you do something like that. But I'm just saying it is possible to do, and some people do in fact file applications like that. But the more likely reason why I've seen, at least in my experience, why someone would file a standalone I-130 is for a variety of reasons. Number one, they might have an old removal order. So the reason I would file an I-130 for someone with an old removal order is because once the I-130 gets approved, if that person is otherwise eligible for a green card or adjustment of status and the only issue is the removal order, I would then use the approved I-130 to reach out to the Department of Homeland Security to try to get them to join our request to reopen the deportation case and fix the old deportation order. We do this all the time. It really depends on what the government policies are at the time, whether or not it's possible to do or not. Right now, it's probably less possible to do than it was even a couple weeks ago when Biden was president. But that's one main reason why I file standalone I-130 petitions for spouses of US citizens. Now, the problem with doing that right now is if you are a deportation priority because you have an old removal order and you're scheduled to attend an I-130 interview with your spouse, there is a chance that ICE could detain you after that interview or before that interview. The chances of that happening, even with a removal order, in my opinion, are very low. Just anecdotally, I haven't seen it happen many times in my experience as an immigration attorney. I do recall it happening a bunch of times when Obama was president, but those people tended to have a removal order plus criminal history when I saw it done anyway. So I don't know what the chances are of you getting detained if you attend a standalone I-130 interview, even if you have a removal order, but it is definitely possible. I mean, you are deportable. You're more than deportable. You have an active deportation order. So attending the interview can be risky, which leaves a lot of people in between like a rock and a hard place, because you need an approved I-130 sometimes to fix that old deportation order and fix your status and become legal, legalize your status entirely. But the process of doing that can end up getting you detained and sometimes deported in some instances. So it's a tricky balancing act, and we really need to analyze what the current government policies are before we file a standalone I-130 petition before USCIS. Another time I've seen USCIS inform Immigration and Customs Enforcement about someone who's applying for a benefit is during the naturalization process. This is incredibly rare. I don't want you to watch this video and your takeaway to be, I shouldn't apply for naturalization. I don't want to become a US citizen if I can get detained. Another instance where I've actually seen someone detained was at their N-400 naturalization interview. Now, I don't want you to watch this and say, I'm not going to file my N-400 now because I could possibly be detained. The one time I saw it done, again under Obama, was because the applicant was convicted of an aggravated felony. Now, aggravated felony is an immigration term for certain classification of criminal offense. It is the highest level immigration offense that you can commit. It's oftentimes reserved for people who are convicted of seriously violent offenses or drug trafficking. There are certain non-violent offenses that could also be classified as aggravated felony, and interestingly, it has nothing to do with whether or not it's classified as a felony or not under state or federal law. Immigration law will reclassify certain offenses as aggravated felonies. If you're convicted of an aggravated felony, first of all, you're never eligible for citizenship because it carries with it lifetime bad character, but it also renders you deportable and you can end up losing your permanent residence. So when someone gets detained after an aggravated felony, first of all, they might not be eligible for bond if it's truly an aggravated felony. They would need to fight their deportation case while detained, while in a jail. Also, the relief available to you after an aggravated felony is very limited. There are very few things you can apply for to avoid your deportation, although there might still be options available, so don't give up hope entirely if you fall into this category. If you have an aggravated felony, you should definitely not file an N-400 application for naturalization because it will be denied if they find out about it, and you're subject to detention and deportation from the United States. A lot of people are asking me, yeah, but what about for the adjustment of status process? What if we filed the I-485 green card application and the I-130 family petition concurrently, simultaneously, and my spouse and I are just waiting for the green card interview? Can my immigrant spouse be detained while the process is pending? And the answer is maybe, but very, very unlikely. I would be absolutely shocked if someone has a pending adjustment of status application and no criminal history and no removal order. That person is very unlikely to be targeted by immigration. In fact, let me tell you a story. During Obama's last presidency, I had two different occasions where Immigration and Customs Enforcement reached out to people who were in the process of hiring me. And they sent them a letter. ICE sent my clients a letter that basically said, we are scheduling for you to come in. This is a call-in appointment. We need you guys to come in. We want you to bring your passport and your suitcase because we want to have a conversation with you. And so my clients immediately informed me and they said like, hey, ICE wants us to bring our passport and our suitcase. What's this conversation going to be like? And my response was, well, if you go to this appointment without planning for it, you might not leave that appointment and be released back into the United States. So in both of those instances, my clients were married to US citizens. And in both of those instances, I don't know why, but my clients thought that just marrying a US citizen by itself will protect me from deportation and put me on some sort of pathway to legal residence. They didn't realize that you have to actually apply for stuff after you get legally married. I meet people all the time who believe this, and it's not entirely illogical. I mean, it kind of makes sense. Once you're married to a US citizen, you feel like you belong in the United States and that you're unlikely to be deported. So in both of those instances, I called the immigration officer and I basically said, look, this person is married to a US citizen. They hired me to do the adjustment of status process. What do you want to do? And the immigration officer basically said, we have a notice to appear. We have documentation to give to your clients saying that we are going to begin their deportation from the United States. However, if you can show me within the next 2 weeks that you have an adjustment of status application pending for your clients, we'll still give them the notice to appear, but we won't file it with the immigration court and your clients can be on their merry way. And that's exactly what we did. We immediately filed the adjustment of status package. We got the receipt notice. I sent it to the ICE officer, and the ICE officer basically said, okay, we're taking your client off our list. We wish them the best of luck in the future, and that was that. So generally speaking, when you have an adjustment of status application and you don't have any criminal history and you don't have a deportation order, generally speaking, you should not be super worried about immigration detaining you. As an extra word of caution, I do right now advise for my adjustment of status clients to carry the I-485 receipt notice with them. It might be overkill, but in the off chance that you have an interaction with Immigration and Customs Enforcement, it might offer a small layer of insulation. They might exercise their discretion favorably and say you're not a priority from deportation, you're clearly on your way to adjusting status in the United States. And by the way, in those instances, if they do put you into removal proceedings, we can still apply for adjustment of status, except instead of doing it in front of USCIS, we would do it in front of an immigration judge. But the chances of success might still be high if you have a good case. Alright guys, that brings us to the end of today's video. I hope this helped some people out. I hope this put your minds at ease if you're going through the adjustment of status process. If you haven't started the process or you're thinking of getting married, I'm going to put out a bunch of videos this week about the risks involved with getting married and applying for adjustment of status. So if you're interested in family-based immigration topics, especially, how Trump's policies can affect them, be sure to subscribe. I'm going to put out a few videos a week on this topic. If you're going to go through this process yourself, or you need an attorney to consult with or an attorney to handle your case from start to finish, be sure to schedule a consultation with me. I would love to speak with you, help you and your family create a plan, and if you'd like, I can represent you throughout the entire process. I'll see you guys next week for another one.